Number 1. Wait, please.
Have you agreed on a date?
Yes, Your Lordships. Your Lordships, on the 9th of April, Your Lordship.
Okay. 9. So what? Single matter whole day. Go on. Yes.
Much obliged, Your Lordships.
This appeal and the connected application is listed today as quotation to be mentioned on court for fixation of a date of hearing. List these matters for hearing on 9th April.
All the Lordship.
Number 2.
Yes, please.
Please, Your Lordship, probably we have failed in our duty on the last day to bring certain aspects before Your Lordship's notice. So it appears that certain errors have come in which appear to be the errors apparent on the face of the record. So on that basis, we have come for an application for review of the order.
What? Where is the order?
No, the order is annexed at Annex 1, at page 13. This
Who is making the application? Who is making the application for review?
Respondent number 4. There are 3 private respondents in the case here. These 3 are the claimants. So there are rival claims. The amount which was already given out, that amount, the finding of the Honorable Court below, the decision below, is that it did not go to the actual owners. Well, although that is always in the Honorable Supreme Court's order also, it is there that who are entitled to the compensation, that is also to be decided by the court below. Now, the court below, the district judge, upon being directed to conduct the inquiry, a judicial process was followed. All the rival claimants were asked to file their claims, and thereafter evidences were used. And after giving proper opportunity of examination, cross-examination, etc., and considering all the evidences, thereafter the finding was arrived at. So in our respective, humble and respectful submission, it was a judicial process, and therefore a judicial
process may have been like judicial, but the appointment was in the capacity of an officer of the court, like a commissioner, like a special referee. It is not a jurisdiction vested by law. Understand?
The reference court will
today the court might direct eviction of a lessee tenant and direct determination of mean profits through a special referee. Now that special referee might conduct the proceedings as if similar to that of a court of law, but that doesn't give him the office of a judge.
So, but here what has happened, the judge who conducted the inquiry, that judge is the reference court also.
Maybe.
Court also. So, what is happening as a result of this, as a result, a judicial inquiry which has been conducted already, that is being subjected again to another judicial.
No, an inquiry conducted by a judge. Today an arbitrator might be a retired judge of the court.
Of course,
but then whatever he does not become an order of a court of law.
No.
It is subject to, in an arbitration, to a setting aside application under section 34.
But the queries which were sought to be answered,
maybe, but if it goes to a judge for affirmation, if he has conducted it properly, he will rubber stamp it. What is the harm?
The evidences which were taken, that will have to be repeated again, and in the process, whatever has emerged out of those evidences, that may be revisited.
No.
There is a risk of that.
Remind us of the fact, the applicant would be the beneficiary if 9 crores is returned.
That is, according to the finding of the judge, applicant is entitled as an owner, but that 80% which has already been released, there has, according to the inquiry which has been conducted, there has not gone to a rightful owner. So this
now who has taken the money?
That someone who has made a claim and who has represented herself to be a owner, but the finding of the judge is that the person was not. She's the.
If it is recovered, it will go to you.
If it is recovered,
you claim to be the owner.
I am one of them. The major part goes to the claimant number 1, and I am the claimant number 3. So these findings which have been arrived at by a judicial process, these are being reopened. So only reopened, then there is a slight possibility.
No, Mr. Chakraborty, please try to think the way we are trying to think. Say, question of determination of mean profits. It goes to a special referee. Now, he takes evidence and he hears arguments and he prepares a report. That so-and-so will get so-and-so per square foot as mean profit for this period aggregating to so-and-so. Then that report goes to the court for the purpose of passing a decree. Now, when it goes to the court for passing a decree, the court does not reopen the evidence. It just sees whether the evidence taken is correct or not. And then affirms or sets aside the report.
If that observation falls from the lordship's lips, that would probably be a proper guidance to this new inquiry which is happening.
We take it as a...
If the reopening of the evidence is not done.
Excess payment has been determined by an officer. This officer was, this district judge was appointed by the court. By this court.
This court only. Pursuant to the order of the Honorable Supreme Court, Apex Court.
So that's the order of the Apex Court?
All right. Apex Court.
It's not working very good. It is not in the review. affidavit affidavit.
It's reference code. Yes. Need not do it afresh. You can go into the papers and see whether the evidence everything is taken care of.
My lord, the plea of non-litigation issued by this court appointing the district judges, my lord, date, my lord, 25th August 2007.
Your Lordship is on the Apex Court order.
Yes. You request 2nd August 2007. 17. We request the Chief Justice of High Court of Meghalaya, page 4 of the order.
My Lord, we request the Chief Justice of the High Court of Meghalaya to nominate a district judge,
Yes.
to determine this matter as far as possible
So it's
within 3 months.
It is just like a special referee.
My Lord, the paragraph before that, my Lord, clarifies that what exactly is to be inquired into, my Lord. The only other issue, if your Lordship is on that, my Lord, which survives is whether the public money has been squandered as suggested by offering high rates of compensation, which is against the rate offered by the owner and the rate at which she purchased just before acquisition. Question as to who is entitled to compensation may also require consideration. This matter may require consideration. Pending such consideration, we enjoin Patricia Luxich from parting with the money available with her, which aspect may be overseen by the Deputy Commissioner concerned, and similarly, money available with the state account may also be kept intact, and the Deputy Commissioner concerned may oversee that aspect also. So we request the Chief Justice of the High Court to nominate a district judge to determine this matter as far as possible within 3 months. Order of the Chief Justice may be put up on the website within 2 weeks. Any parties interested in the matter are at liberty to put forward their claims. So claims were put forward, brother. Claims were put forward, evidences were taken, and then
You see why it is taken as a commissioner's report. The report of the district judge, it doesn't say judgment or order or decree. The report of the district judge will be submitted to the High Court, which will be considered and decided on the judicial side.
right, madam. Of course.
So the district judge must have found the report.
For submitted the report. The report is before your Lordship. It has been submitted by the Honourable District Judge. Now, my only one major apprehension, others apart, is that if again a judicial process is revisited or reopened, in that case, all the findings and the arrived at by the in this inquiry, that would probably be negated. There is a possibility of that being negated, So if at least your Lordships are pleased to give a clarification on that,
We are prepared to give a clarification because assessment of the report, either the report is accepted or the judge would have to take fresh evidence. Either course is there. So we have relegated it to the district judge. And as per the Supreme Court's report, again the district judge's order will come to us for affirmation.
Before your Lordship.
Yes.
Normally. That is what
Like on the judicial side, we thought it fit and proper to do this because we can't have evidence here.
Yes, but what I was, as your Lordship are the view that finding of the district judge amounts to another piece of evidence only. But in my humble and respectful submission, because that was arrived at after following a judicial process. So that repetition of the judicial process would not be fair or proper.
All right. In that way, it is qualified.
My Lord, may I submit one? My Lord, I appear for Airports Authority of India, my Lord.
Yes.
My Lord, as Lord has seen that was simply an inquiry conducted in the capacity as inquiry officer, my Lord. Now that was not a trial, my Lord, as supposed to be a trial under the Land Acquisition Act by the reference court, my Lord. My Lord, that aspect, Lordship, may kindly keep.
Yes.
My Lord, I appear for the respondent number 5.
You have received the money.
I have received the money, my Lord. My Lord, after receiving the money, I have parted with the money with the petitioner here who has received 5 crores and the other claimant, the claimant number 2, State Dakar, who has received 7 crores. Now, my Lord, the inquiry officer, the district judge who was entrusted with the inquiry, my Lord, in my submission, my Lord, was not empowered to take up the matter like a civil court and to decide complicated issues such as title, my Lord. No doubt the evidence was taken, my Lord. If my Lord will come to the order of the Supreme Court dated 2nd of August 2017, my Lord. My Lord, if I may take my Lord to the second page of the order of the Supreme Court, my Lord, the order dated 2nd August 2017. My Lord, this order was passed when a third party who is not a party to these proceedings had approached the Honorable Apex Court by way of a special leave.
Yes.
My Lord, internal page 2 of the order dated 2nd August 2017, if I am permitted to read, my Lord. May I, my Lord? During the course of the hearing, it has been admitted by the learned counsel for so-and-so that at least a sum of so-and-so has been received on our account on April so-and-so, while according to the counsel for so-and-so, rupees 7 crores has been paid to so-and-so. Learned counsel is unable to state whether the amount which was received in the account of so-and-so is available or not. Learned counsel for so-and-so has also stated that the sum of 10 to 12 crores is lying with her in the bank. The amount which is not available in the bank will be credited to such account within 2 weeks from today. We are of the view that the expansion of the airport is in public interest and in no circumstances the said project should be obstructed. Accordingly, we direct that the possession of the acquired land to be taken over forthwith, the area to be given to the Army Authority be also handed over forthwith. It is not necessary to go into the question of whether the High Court have taken suo motu proceedings having regard to the public interest involved. As far as the claim of the appellant for compensation on account of tenancy, we do not have any specific pleadings about the area of tenancy, the date when the tenancy commenced, and the consideration for tenancy. In the absence of any tangible and verifiable claim, we cannot entertain such claim in these proceedings. However, the appellants are not debarred from taking any other remedies for which we do not express any opinion. As regards the claim of State Dakar, that the sale deed on that behalf was not genuine, such an issue cannot also be gone into by us, in view of the fact that State Dakar has already received substantial payment and no grievance was raised by her till the time of filing of the appeal. So, my Lord, the parties have received their substantial sum have received their share, and no grievance was raised till the time this special leave petition, which was filed by a third party, before
Before the district judge,
my lord,
who was acting as a nominee of the Chief Justice,
my lord,
pursuant to this order of the
My lord.
Supreme Court, you should have made your submissions before
my
that.
lord, we have made our submissions, my lord.
That you should have made your submissions that out of this money I have given so and so.
My lord,
Then
all the submissions were made, my lord.
Then the judge would have directed that you make over that money.
My lord, all the submissions were made, my lord. The problem in the
In a review application, it doesn't lie.
my lord, review application, my lord, in my humble submission will not be maintainable because my lord has considered all the aspects, my lord. There is no error which is apparent on the face of the record, my lord, but that will warrant exercise of.
We are not reviewing the order. We are just making a clarification.
My lord.
We are not reviewing the order.
So my lord, in my humble submission, my lord, the inquiry court was not clothed with the power of a civil court to look into these issues, my lord. My lord, a reference is required to be made since these are proceedings arising out of a land acquisition matter, my lord. A reference in terms of.
I would just request you to read that provision of the Civil Procedure Code,
My lord.
where there is a provision for determination of mean profits
My lord.
after a decree for eviction is passed.
My lord.
It is like that.
My lord, my lord.
Either the court determines it
My lord.
or refers it to a special.
My lord, to a special referee, my lord.
Yes, it is like that.
My lord.
So we will clarify to that effect.
My lord, however, my lord, in my respectful submission, my lord, fresh evidence is required to be laid, my lord.
No, that when the special referee's report comes to the court
My lord.
for confirmation of mean profits, the court decides that
My lord.
whether to take fresh evidence or to accept that report. That is to be left to the court.
My lord, then in that event, my lord, may I humbly pray that the district judge will look into the report, my lord, and
You just please listen to
my
our
lord,
order.
there are
After the order is passed, if you have something to say, you can say. You will not have anything to say. Please listen to this order. Please take them.
My lord, with
Again, what happened?
I represent on behalf of the claimant number 1, madam. I just invite lordship attention to the order dated 21st February 2023, passed by this honorable.
Yes, what is the order?
My lord, it says, lordship permission. Well, this order for second inquiry, well, this order was passed. It says that, my lord, may read up. Now, the presence of the three principal dramatis persona has been secured. The court today gave an option to the three as to whether they would prefer the determination of quantum of excess compensation, if any, to be before a nominee before whom all the evidence may be led as and may have been the basis for the Supreme Court order 2nd August 2017, or whether such parties would be agreeable for fact-finding exercise to be conducted by this court itself upon the abject failure thereof in the report dated 24th November 2017. The three opposite parties had accepted that the matter may be required to be looked into by the present district judge report district strictly in terms of the two issues framed by the Honorable Supreme Court in the order dated census 2017 to determine whether any excess compensation was paid to the as well owners, and if so, to what extent. Further, the inquiry should reveal what amount and to what extent should now be repaid or compensated, and who would be entitled to such repayment or compensation. Accordingly, the present district judge report district is directed to inquire into the matter afresh without being unduly influenced by the perfunctory report of November 24, 2017, and to receive evidence to determine the factum and the quantum involved, if any. The parties, particularly the three opposite persons, have assured that the court that they would cooperate in the inquiry and present the best evidence available. The district judge report district will proceed to adjudicate the matter in court.
No, why are you placing this order?
I'm supporting the contention of the melody review petitioner that evidence has been led, cross-examination has been done,
Yes.
exhibit has been done, my lord. That therefore, it doesn't require for fresh evidence.
Please take them. This is an application for review. Of our judgment and order dated 26th February 2025. Paragraph. We have heard learned counsel for all the parties. Paragraph. We do not find any cause to review our order. However, some clarifications are necessary for proper and speedy implementation of the said order. First of all, the reference may be made to the Supreme Court order dated 2nd August 2017, pursuant to which this whole exercise was started. Full stop. The material part of the said order is set out below. Page 4, Mr. Lam, there are many markings, last paragraph, from we request till the end. There are two directions in this order are important. First, the Chief Justice of this court was asked to nominate a district judge to determine the matter in issue, i.e., payment of excess compensation for acquisition of land to expand the Shillong airport. At Umrao, what is that place? Umrao. Secondly, the decision of the district judge was to be considered as a report to be petition, considered and decided on the judicial side, unquote, by us. Therefore, we have rightly noted at page 3 of our said order dated 16th February 2025 that the inquiry report of the district judge the report of the district judge was to be taken as an inquiry report or assessment of mean profits by a special referee. taking the matter up on our judicial side, we were of the view that consideration of the report might involve assessment of the evidence taken by the district judge and may also require taking of fresh evidence if required. Paragraph. So, on our judicial side, we refer the matter to the District and Sessions Judge Shillong, who is also the Special Judicial Officer under the Land Acquisition Act, to consider the report of the district judge. Further, we directed that the decision would be transmitted to this court for passing a final order. Paragraph. Mr. Chakraborty, the senior advocate appearing for the applicant, had expresses the apprehension that the part of our order directing the Special Judicial Officer to take evidence would reopen the whole matter and involve de novo adjudication. Full stop. According to Learned Counsel, adjudication has already been done by the district judge nominated by the Chief Justice. Secondly, he submits that the report, that the reference to the report as an expert opinion is likely to cause confusion and further reopen the entire matter. However, we would like to make clarification on these two issues only. The report of the nominated district judge would be taken in the same way as a report of the special referee determining mean profits is taken by the court. Full stop. The facts and the evidence before the special referee are usually assessed by the judge And thereupon, he comes to the conclusion whether the determination is correct or not. Full stop. If the judge finds that either the special deputy has acted on insufficient evidence or has assessed the evidence wrongly, or that relevant evidence has not been considered or produced, or that fresh evidence is required to establish the claim of the claimant, then he orders evidence to be taken. We clarify that the special judicial officer may follow the same procedure. Otherwise, he is to act on the records before the nominated district judge and pronounce his ruling. We clarify the order dated 26 February 2025 to the above extent only. You had one more line. The report of the nominated district judge shall be taken as records of proceedings instead of, within quotation, piece of evidence. This application for review is disposed of accordingly.
Very grateful, very much. Thank you.
My Lord, just one clarification I want to give, that my Lord has mentioned a special judicial officer under the new act. I think that is called the authority, my Lord. Under the new
I don't know, that is there in the order.
well,
You see the order that is recorded.
my
That was told to us, we said that.
my oblige.
Number 3.
Yes.
May I please, Your Lordship? Your Lordship, due to some medical emergency, the game counsel could not come. Let this matter come tomorrow, Your Lordship. Tomorrow or day after tomorrow.
You are paying for the first time.
Yes, Your Lordship.
Appeal.
Very simple orders in partial learning. I don't understand why they file appeal, madam.
W together cipher. CIPHER.
Madam, the cryptologist, madam.
Yes. What do you say, Mr. Deputy Solicitor General?
My lord, lots of kindness, because whatever the grievance was, my lord, during the pendency of the matter, that was resolved, but accordingly the matter was closed by the learned signatures. Against that order they've come. Page 59, your lordship is.
If we dismiss the appeal, her senior will come running the next day and say that I have something to say.
Well, any day, my lord, tomorrow.
Where is the order?
Page 59, 59. The matter was regarding backdating of his MSCP, my lord. So that was done. The only question remained the calculation, my lord. And the learned single judge directed that he will cooperate with the department and will calculate the areas.
What is wrong with this order?
Pardon, Your Lordship.
What is wrong with this order?
Apologize, Your Lordship. I do not have the brief.
Anyway, let's see what to do. Keep it for tomorrow. On the prayer of learned counsel for the appellant, this appeal is adjourned for the day.
Number 4.
Your Lordship.
Please, Your Lordships.
Yes.
Lordships, I have received 2 affidavits filed by the respondents. I am praying for 2 weeks' time to file a reply there to Lordship, a rejoinder.
But this matter, nothing survives, my lord. My lord, here what happened, my lord, they filed a PIL. No, firstly, my lord, the PIL is misconceived in this kind of matter. Here what happened, my lord, the stadium was to be constructed in Turang, my lord, in Garo Hills. I am the contractor, you are the contractor, my lord. Now what happened, there was a heavy flood, my lord, flash flood. And because of that a temporary wall collapsed. My lord, kindly come to page 9 of my affidavit, my lord.
Any orders was here? Yes, please.
On page 9 of my affidavit of respondent number 7, my lord.
Yes.
So this, because of flash flood, my lord, on particular day in last year, my lord, the temporary boundary wall, it collapsed, my lord. And now let's kindly come to page 11, my lord. We have duly constructed it as the RCC wall, my lord. Page 11 will not subsist, my lord. 11 and 12, my lord. So in my embassy, nothing survives, my lord, and this PIL for this kind of matters, my lord.
If I may submit, Lordship. Lordship, what happened is this particular stadium was inaugurated earlier in 2022. Now in the year in 2023, Lordship, for the first time it collapsed. A portion of the stadium collapsed. Being grieved with that, we had filed the first PIL by the same petitioner before this Honorable Court. That PIL was, Lordship, entertained by this Honorable Court and finally came to be disposed of in the month of August 2023 with the direction to the respondents to carry out the reconstruction of that collapsed portion there and to also carry out a assessment to ensure that the entire stadium is fit for use. That matter was disposed of, Lordship, in August 2023. Again in June 2024, again a portion collapsed. Now thereafter, Lordship, we have filed this second PIL which was entertained. Lordship, and now they have filed an affidavit at very recently saying that the wall has been reconstructed. However, Lordship, we have also obtained information through the RTI, under the RTI Act, that the directions which were passed to carry out a proper reconstruction for assessment by the technical committee and so on, those have never been complied. So I may be allowed to put a short reply. Thereafter, matter can be heard and disposed of, Lordship.
Because he's a busybody, my lord.
In 2 years, the same stadium
For small issues,
time and again.
filing PIL, my lord.
Only the collapses of the wall.
So temporary fencing wall, my lord. Well, while the construction, my lord, it was a big stadium, my lord, comprising of 3 spectator stand, 1 football ground, 1 indoor hall, swimming pool, my lord, 1 basketball and badminton court, my lord, and the service blocks, landscaping. So it is a big sports complex, my lord. And because there was encroachment by people, my lord.
What sports is played? Football.
Mainly for lots of kindly comes to page 2 of my same affidavit, my lord. Para 4A, my lord. Now, para 4A, that the answering respondent is the contractor for construction of a PES AMA integrated sports complex at Tura. The project is spread over land measuring about 10 acres and mainly comprised of the following components: construction of 3 numbers of spectator stands, construction of a football ground, construction of 1 indoor hall, swimming pool, construction of 1 indoor hall, basketball and badminton courts, external developments including service block, landscaping, boundary wall, internal roads, water drainage, sewage treatment plant, parking area, etc. And then we stated, my lord, on 2nd of June 2024.
Constructed with the government.
It's a government project, my lord. We are the contractors.
The collapse or damage is only of the boundary wall.
Only the boundary wall, my lord. And that also is not a permanent boundary wall, my lord. That was only a temporary boundary wall till the construction goes on, my lord. And I've indicated, my lord, now we've corrected the permanent RCC boundary wall, my lord, as per the
And what was collapsing earlier was the temporary wall.
temporary fencing wall. I've stated in my affidavit. I'll just point that out.
What collapsed initially was a major portion.
Initial that matter is over, my lord. Right now, the present PIL is only concerning this boundary wall, my lord.
Who is your client?
Lordship, he is a resident of that area, Lordship.
Or where?
In and around the stadium at Tura. So at this stage, Lordship, my only prayer is that I may be allowed to file a short reply to their affidavits, a comprehensive reply.
On what?
On the information that's predominantly on the information which I've obtained through RTI, Lordship, because this is the second time I'm coming before this court. In 2 years, the same stadium portions of the stadium has collapsed twice, Lordship.
But that has been replaced by a permanent structure.
Now, Lordship.
Then?
So that is one part of it, Lordship. And with regard to the issue of, on the last round of litigation, clear directions were passed for a proper assessment before the stadium is again used. That also has never been done, Lordship. It is in the interest of the public that stadium in 2 years, Lordship, of its inauguration is collapsed twice, Lordship.
By the word used, stadium collapse, that's very unfair word.
Portion of the stadium.
It is not even a portion of stadium, my lord.
Even in this occasion, one casualty was there, Lordship. Yes. They have compensated, they have stated.
Somebody died.
There is no casualty, my lord. We have stated very categorically in my affidavit, my lord. Para page 3, my lord, para E.
News reports are there, Lordship. There.
Para E, my lord. Page 3.
They've done the permanent repair. No, so people isn't it? Please take them. The government has made a mega sports complex at Pura. So, it is known as PA Sangma, Integrated Sports Complex. It is spread over 10 acres. Within itself, it has a football ground, one indoor swimming pool, and one indoor basketball and badminton court. Its beauty is further advanced by landscaping. Full stop. One resident of the area filed this public interest litigation, which was entertained by the court. Full stop. The complaint was an inquiry into collapse of a boundary wall. This court entertained it. Full stop. Orders were passed from time to time. Full stop. The boundary wall was repaired. Full stop. It broke again. Full stop. Again it was repaired. Paragraph. This repaired and the concerned public interest litigation disposed of. This is a fresh writ petition complaining of the boundary wall breaking down again. Paragraph. Learned Deputy Solicitor General appealing for the state.
The contractor.
Contractor.
Number 7.
Who's for the state?
Lordship, on me personal lordship is being led by Mr. Khan, by K. Khan lordship, AAG.
No, you endorse the submission of Mr. Muzika.
Lordship. Lordship, there's an incident report which have been closed in my.
No, you have.
Yes, Lordship.
Both the state represented by so-and-so and Dr. Muzika representing the contractor have made their submissions. Paragraph, their submission is that first of all, the boundary wall which broke down was temporary in nature. Full stop. There was severe rain and flooding with water rushing towards the temporary structure, damaging it more than once. But it was repaired. Full stop. Now there is a permanent boundary wall. Full stop. There is no problem in the stadium or in the sports complex. However, learned counsel for the petitioner says that this work was done without obtaining technical knowledge. Now, without proper technical evaluation and decision. We sound a note of caution regarding entertainment of public interest litigation. Paragraph. It is not that any alleged fault or dereliction of duty or failure to act on the part of the government that is to be brought to the notice of the court in a public interest litigation. If any person is aggrieved, the proper remedy is regular litigation between the person aggrieved and the government. Only if there is some grave dereliction of duty affecting the public at large, and that the court may be approached in this jurisdiction. If every alleged act of commission or omission of the government becomes subject matter of public interest litigation, neither the government nor the court can function. Public interest litigation is also not the domain for busybodies. Full stop. In this case, there has been not even an injury caused to any person. There was breakdown of a temporary structure which was repaired from time to time. There is no complaint that the integrated sports complex is unable to function because of some inaction on the part of the government. Paragraph. Unnecessary time of the court has been consumed by this litigation. We dispose of this public interest litigation with the observation that the permanent wall constructed would continue to stand and not continue to stand and not continue to stand and serve the sports complex. Poster. This poster.
Published.
Next. What is the next matter?
Item number 5.
Your Lordship,
Yes.
my lord, I am appearing for applicant, Your Lordship. Service upon respondent number 1 to 4, it has been completed, Your Lordship. I have filed affidavit to that effect also, my lord. Service is complete, my lord, upon all the respondents.
I'm entering appearance on behalf of respondent number 4, Your Lordship.
So delay of only 44 days, my lord, only because of long vacation, my lord. It was applied.
We are condoning the delay.
Yes, Your Lordship, no objection.
Sufficient causes shown. We condone the delay in filing the appeal. This application under Section 5 of the Limitation Act is allowed. The registry is directed to register the appeal. When it should be put it for admission.
On 7th, my lord, 7th April, if it not inconvenient, my lord.
Seventh is likely to be declared a holiday here.
Oh, other matters are still on 7th.
Eighth,
8 in place of before that, my lord, any date, my lord, 6, 5,
5 is Saturday.
2nd of April, my lord.
Third of April.
3rd of April, my lord.
List is appealed for admission on 3rd April.
My lord.
Number 6.
Much obliged.
Deep your Bible.
Yes.
Lordship,
Where is the other side?
the other side is there.
Yes. You are for the appellant.
I am for the appellant, and they also have filed the cross appeal. There are 2 appeals.
Appeal is ready for hearing.
Yes, Lordship.
Paper book filed.
That memo of appeal to be considered as a paper book.
So when do we take up the appeal?
And your Lordship desire, otherwise we are ready. Tomorrow, day after, even today.
Tomorrow we will take it up, this appeal.
So tomorrow, slight difficulty, my lords, day after tomorrow, but it's not inconvenient with my lords.
All right. Thursday.
Thursday.
All right. By consent of learned counsel for the parties, list this appeal on 27th.
I'll oblige.
7.
Yes, please.
Please, Lordship. Lordship, this is a writ appeal directed against the judgment of the learned single judge.
Hold the mic towards yourself.
I'm sorry, Lordship.
Yes.
Lordship, this is a writ appeal against the judgment of the learned single judge, where appellant has been dismissed from service because of unauthorized absence. Lordship, today I'm having a little difficulty, Lordship. I'm praying for a short.
Appeal is ready for hearing.
Appeal is ready for, otherwise ready for hearing, Lordship. Paper books have been filed.
Adjourn for the day.
I'll have it Monday next week, Lordship, anytime next week.
Third.
Lordship.
Same. By consent, third.
Much
The appeal is
obliged.
fixed for hearing on third.
Obliged.
Yes.
Number 8.
8. Yes.
This is also an appeal, Mal. It is ready for hearing otherwise.
Yes, sir.
paperwork has been filed. My lord.
Your Lordships, the conducting counsel for the respondent is having personal difficulties. Let the matter come up after 2 weeks, Your Lordships.
There are a lot of matters here, important matters. Nobody wants to do them.
My lord.
Otherwise, the court would be occupied
My lord.
more than the time allotted, and why 4 judges? 8 judges would be needed here.
Even for me, it becomes difficult, my lord. I come prepared, my lord, the matter is adjourned. I stopped reading the files.
22nd April, same order.
Is it April? My lord.
You first write, Learned, or the respondent pays for adjournment. Then 22nd, consent of parties, Learned Counsel. Next,
Number 9.
yes,
I am appearing for the respondent in this matter, my lord.
yes. Who's for the appellant?
Please, Your Lordship. Your Lordship, I'm appearing on behalf of Mr. D. Das. Your Lordship, I'm praying for some accommodation on his behalf as he is suffering from back injury. Doctor,
Appellant, you're for the appellant.
I'm for the appellant. Mr.
Okay.
D. Das, senior advocate, is for the appellant.
Learned Counsel for the appellant pays for adjournment on the ground of, on the medical ground of her senior, then by consent of Learned Counsel for the parties. 22nd, Mr. Kumar?
Yes, my lord. Yes, my lord. Yes, my lord.
Yes. Next,
Number 10.
My lord, this is the matter where with a kind intervention of my lords, where a young student was allowed to sit for the exam, my lord.
Yes, yes.
For LLB exam, my lord. So the paper books are ready, my lord. It's been supplied with all the parties, my lord. So in this matter, my lord, by my lord's order dated 5th of December 2024, 5th of December 2024, my lord, at paragraph, the second page, my lord, from the last paragraph of the second page, this is the crux of the matter, my lord. May I just read, my lord? Prima facie, we are of the view that this rule is to be interpreted reasonably when it is possible for the student to attend classes and he deliberately or negligently does not do
do
so.
we remember the order? Now, what is the,
My lord, so now the student have sat for the exam, and as per his instructions,
if the refusal was rightful, then his result will not be published.
My lord.
But if it is found to be wrongful, then he would be granted the degree. That's all.
yes, that's all, my lord, yes. And the explanations here also, my lord, that since from the first day of the semester, he had suffered sickness because of which deterred him from attending his classes. Otherwise, his all other semesters, my lord, he has never fallen short of his attendance, and he has explained it clearly. Subsequently, finally, he had to be admitted in the hospital, 2 hospitals.
Mr. Chakraborty, shall you clear tomorrow?
Well, as your lordship, as per your lordship's convenience.
Tomorrow, my lord. Yes.
Yes, we have heard Learned Counsel for the parties. List is appealed for further hearing on 25th.
25th.
No.
26. Obliged.
Obliged, your lordship.
Number 11.
My lord, this matter pertains to IVF treatment, my lord.
Sorry?
IVF treatment, my lord, regarding
Yes.
pregnancy. My lord, by the last order,
Interim order carried out.
my lord, by the last order, my lord has given
I have
direction.
remember.
My lord, as far as the petitioner is concerned, my lord, it has been found, my lord, in terms of her report earlier, my lord, that her eggs are not viable. So the donor egg is required, my lord, and even for her husband also. So, my lord, in terms of the order of the Honorable Kolkata High Court, my lord, even in that case, which my lord has referred,
there also, my lord, the donor's egg was used, my lord. So if that part is recorded in the order, my lord, then they can proceed.
Donor's egg means the child will not be her or somebody else's. He is right or wrong, we do not know. Huh?
Yes, there is, my lord, in terms of the act, my lord, there is a bank, donor bank. So if she is allowed to.
No, that means she will be carrying somebody else's child. It is not her egg.
It is not her egg. My lord, in cases where, my lord, they cannot, their own egg is not suitable, my lord, in that case they use the donor egg, my lord. It is in terms of the act itself, my lord.
Who is appearing for the hospital?
My lord.
Yes.
That's correct, my lord. We have in there her egg is not, my lord, viable. Immunism viable. So in that case, the IVF can't be now.
We will hear it in detail tomorrow. Put it as the first matter tomorrow. It needs to be, please be ready and come. Why it cannot, this procedure cannot be performed at all?
No, my lord, that's why we can proceed on if a lordship's permit for allowing her to get a donor. We can provide we have bank ourselves, so that can be done in that way.
They just need an order from the court, my lord, that they can go ahead with the procedure, my lord, using the donor egg.
No, in the interim order we passed?
Yes, my lord, in the interim order, my lord, has already reflected the order of the Kolkata High Court, and in that also, my lord, donor egg was used, my lord. Order dated 4/3/2025, my lord. Last paragraph, my lord, of the order. Saswati.
Please take it out. Let me done with the report. Institute of Human Reproduction, bracket IHR, a unit of Goenka Nursing Home, Private Limited, Guwahati, refused to perform in vitro fertilization, IVF, on the writ petitioner as she was just over 50 years of age and the and section 21 within bracket G within bracket I of the Assisted Technology bracket Regulation Act 2021 did not permit a woman below the age of 50 years to undergo the procedure. She sought for orders of the court to perform the procedure. Earlier, this court had passed interim orders asking the hospital to furnish an expert report. It did furnish a report, but it was very negative as far as the petitioner was concerned. It pointed to a high risk factor for her. Paragraph. In our order dated 4th March 2025, we made inter alia the following observation. Internal page 3, pencil marked. Paragraph, we passed an interim order in line with the interim order dated 24th March 2023, passed by the Calcutta High Court, in a similar writ petition, bracket, WPA, you please put this, WPA so-and-so versus so-and-so, page 3 of the order. It is there in bold. What else is we passed an interim order? We passed an interim order. Yes, comma to the following effect. The writ was to be heard out in detail, but pending hearing of the writ, the embryo was allowed to be performed with sperm and donor eggs and properly preserved. Paragraph. Here, the learned counsel for the petitioner submits that this interim order was sought to be carried out by the hospital, but they found the egg of the petitioner.
And also for the husband, my lord. And also for the husband, my lord, the sperm is not viable. Even for the husband also, my lord.
Then nothing. You dismiss the writ. And the egg, well, what you will do? You will take somebody else's.
My lord, it is provided under the act, my lord. It is allowed.
No, nothing. His is also not there. What you will do? Experiment.
My lord, once the embryo is, my lord, develops, he can give birth to the baby, my lord.
Whose baby? Neither husbands nor wives. Please take down. You should have said this before. Yes, please take down. Well, what have I said? The wife, the egg of the petitioner as well as the sperm of the husband to be non-productive or inactive. Paragraph. In that view of the matter, there is no point in hearing out this very contentious issue. It would serve no purpose at all. For the reason that the procedure would become an experimentation for birth of a child which neither has any connection with the petitioner or her husband. Full stop. Stretching the act for experimentation purpose will be the last thing in the mind of this court. This writ petition is accordingly dismissed. No order.
Obligation, my lord.